So hi everyone, I'm Avery Vold. I'm the VP of Academic Research Investments and Life Science at IS, or Innovation Saskatchewan. And I want to thank you all for joining us for our Discover Series event. Whether you're online or here in person, we're really glad that you're part of today's conversation. So before we start, I would like to acknowledge that we are gathered on Treaty 4 territory and homeland of the Métis. And while we're here meeting in Regina, our work does span across the treaty territories throughout the province. These lands have long been places of learning, discovery, innovation, and community, and we're really grateful to continue that tradition today. So the Discover series, for folks who haven't attended before, is all about bringing people together and bringing together expertise from across our ecosystem to explore topics that matter to Saskatchewan's future. Our goal is to share ideas, create connections, and have honest conversations about the opportunities and challenges shaping research, innovation, and economic growth. And today's topic is a great example of that. Intellectual property can seem complex or intimidating, but it's becoming increasingly important for researchers, entrepreneurs, and organizations of every size. In a world where ideas, data, and knowledge are often the most valuable assets, understanding how to identify, protect, and leverage IP can be the difference between creating value for others and creating value here at home. So before we start, a few things. There is going to be an opportunity for questions, but we're going to save questions for the end of the presentation. So please feel free to hold them until then. Folks online, you can submit your questions in the chat. And then for folks in the room here in Regina, we will have this mic that we can run to you, or maybe we'll put it in the middle, but we will get the mic to you. If you have a question, just raise your hand. And for those who are here, please continue to grab food and drink. So now I'm really happy to introduce our speaker for today, Corey Furman. So Corey is a registered Canadian patent and trademark agent and founder of Furman IP Law and Strategy PC right here in Regina. He has more than 30 years experience advising businesses of all sizes on protecting, managing, and commercializing IP. And I'm proud to say he's brought that expertise to our Regina Collider, which is just right upstairs here. So please join me today in welcoming Corey.
I'm gonna try to stand. Is this working? Hopefully you guys can hear me all right. I am gonna turn that off.
Oh no, I think you need that to broadcast.
Do you need this too?
Yeah.
Okay, very good. I'm a better lawyer than a tech guy. So nice to be here today and meet you all. I've seen a few folks that I recognize from the Collider upstairs and from around the park, and that I've just met over many years in Saskatchewan. I'm happy to have a little time to have a chat today about IP and sort of identifying IP issues in your business and opportunities in your business. Truthfully, I was laughing when I or my office is upstairs at the park here, and you can stumble by and see me anytime, and we can have a little chat about how I might be able to help. My background, in Saskatchewan, I grew up in farm country just outside Swift Current, so in the ag space in the 80s. It's funny, I was one of I kind of show my age a little bit when I say this, but I was one of the people who in the 90s said that I was in Regina doing my articles and getting called to the bar around the time that we were all seeing who was going to be one of the last people out to turn off the lights. And then we all stayed, and I'm excited. I am always excited to meet people in the tech space and in the startup community to hear what you're doing and talk about how happy I am that you're doing it here. So and I am not on Avery's payroll to plug Saskatchewan IP and Saskatchewan tech, but it's certainly a big part of what I enjoy. Before my law school, I did my BA at the U of S, so I'm a U of S grad, and I've been in Regina here ever since. So Nice to see you all, and I'll kind of jump into it here. What I thought I would try to talk about a little bit is I'll talk about the different types of IP assets you might uncover in your business or in your project. We can talk a little bit about sort of opportunities and challenges that you might face in the IP space. To be honest, there's probably a handful of you that have been around the track a couple times already that will know what these all are. But again, I'm hoping that it'll at least give you an opportunity to identify some of the issues to maximize the value of the IP in your business. So, what is IP? Lots of times, you'll that's oftentimes a question that I would start with is what is intellectual property? And there's a lot of ways to describe it, but it's an intangible asset in your business that are, it's what's in your brain, what's on, heaven forbid, I used to say what's on the page. Now it's what's on the screen. But it's sort of in the software space, it might be software, business methods, those types of things. Over into the chemistry space, it might be, compounds, formulas, those types of things. But so an idea itself isn't what's protected, it's the expression of the idea. So we can talk about that in a little more detail as we spin down here about the differences between copyright, trademark, patents, those kinds of things. I should actually see, okay, you guys, it's not working. No. Okay, we're gonna go. Oh, there we go. Got it to work. So some of the reasons why this matters for your business and where you might find sort of opportunity and challenges to build out some knowledge in a portfolio of IP assets in your business, and so, sort of why it matters. IP can matter from a competitive perspective to kind of to use it to block your competitors or build a bit of an exclusion zone around your business. Or sometimes, frankly, if you're working a little bit, and there's nothing wrong with this, but if you're working in a Me Too space, you may not be building a fence around what you're doing. But it's good to in those cases, it's good to kind of, from an IP perspective, understand what the landscape looks like and know who's out there. Make yourself harder to copy and make sure you're not, stepping on somebody else's toes. Sometimes you can create licensing revenue for your business with IP assets. Frankly, in a bigger picture, you may also be looking if if you're not licensing, you might be using your IP as an asset to back the value of your company if you're looking to do financing, those types of things, through to even if you're, heaven forbid, lots of times people are actually planning towards their exit. And planning towards the exit, part of that might also be, built around what are the likely exit scenarios and having a good IP asset strategy in place there. See if this works here. Okay, it's not working. The different categories of assets that I'll talk about here for a second. My apologies, I probably am going to have to keep on asking these guys to click for me because either I'm click challenged or it's not working, one of the two. But different categories of IP assets that you would probably find in your project. Everybody's heard about patents, trademarks, those types of things. Designs, sort of industrial designs is what they call them in Canada, or they call them design patents in the US, for example. A design where a patent protects the utility of something. A design is sort of the appearance of a product. So, it's specifically non-utilitarian. Copyright exists in the software space, for example, exists in your code, in your expression of ideas and those kinds of things. In a more creative space, even if you're an artist or something like that, copyright will exist in the images you create, the music you write, those kinds of things. And then finally, sort of another category of IP that is probably as important to your business as others, but people don't think much about, is the trade secrets and sort of confidential information, those kinds of things. Hence the need that I freaked out when I saw Scott and I talking over here, and these guys told me there was a transcript on the screen of everything that we were saying. Basically with trade secrets, oftentimes a trade secret strategy is something that you would use in your business to protect things that either aren't they're not patentable. You don't want to disclose them with a patent because you don't want to tell anyone what you're doing. Even from a business information perspective, it might be things like, your customer list and those kinds of things. Um, that's what trade secrets are. And there's a little bit different way to protect those. You there's a little bit of cross your fingers and pray with trade secrets, but also having proper sort of trade secrecy provisions in your employment agreements or using NDAs with people you're talking to and those kinds of things. So those are the categories that you would sometimes find to okay. Oh, I clicked it and it worked. What the heck? So I'm going to talk a little bit. We'll see if it worked. Can you hit it again? So patents, I'll talk a little bit first about this. And if you don't mind, can you give me a wave or something when I got about five or 10 minutes left? Because I have a tendency to talk a lot, and I want to be sure that I don't leave these guys hanging with too many things I haven't at least scraped over before we can go into questions. But with patents, in terms of what you can patent, the concept of patentability typically is primarily focused on a novel product or process or inventions, effectively. The method of doing something, the way that a product works, the way that a product is manufactured. Should ask, I know there's some guys over here that are working in the software space. Is anybody working more in the manufacturing space that's here? Yeah, both. So in the manufacturing space, the patent stuff you might find might apply to your method of manufacture of something, or it might apply even to whatever the product is you're making. It might apply to the way it works. So and for something to be patentable, it has to be novel and it has to be novel. So it can't have been done by someone else before, either on a standalone basis, somebody having done the whole thing, or a couple people having the test that the patent office applies is basically the not the sort of the person skilled in the art is the person that is how they apply the test of patentability and to assess novelty or obviousness. I won't dive much deeper there because I want to keep going and get through, but that's sort of what that test is. Something also has to be, in addition to being sort of novel and inventive, it has to have utility. So I don't have it here. The picture that I used to use of a patent drawing of what I always thought, according to my wife, was questionably utilitarian at best, was a patent. There's a US patent for that I had found that I used to use as an example of nylon stockings that have bubbles of hair remover embedded in the product so that when the hairs on your leg pop them, it oozes out on your leg. And that apparently was utilitarian. They convinced the patent office that that was workable and whatever. So that's a bad example, but something that it has to have a use. So lots of times, if it doesn't have utility, the question becomes how or why is it patentable? In a Canadian and US context, for example, so that's the general test of patentability country by country. It might vary a little bit, but in Canada, for example, for something to be patentable, in Canada, we can't patent a method of medical treatment. And we can't patent abstract math. So for something, if we're lots of times we're claiming in a patent application some kind of a business method and sort of how it mathematically works on a data structure or something like that. And that's okay, but we're not able to just patent sort of a formula itself because that's said to be abstract and not patentable. And in the Canadian context, the method of medical treatment thing is there versus in other countries it varies. So for example, the same abstract theorem math isn't patentable stuff applies in the US market. The test's a little different, case law is a little different, but same thing is there. The method of medical treatment ban in Canada, however, is not the case in the States. And country by country, it varies a little bit. But so those are some of the reasons, or sort of some of the basic, when we go file a patent application, if we can convince the patent office that we're kind of at least crossing those thresholds, maybe we're at least in the game to have a chat some more about whether what we're doing is more broadly patentable. Let me see if I can click here. Oh, heaven forbid, it worked again. Apparently I just had to pound on it. So what does a patent do? It gives you the right to exclude someone else from doing the same thing. And if you ever go look up a patent document on Google Patents or on the USPTO or SEPA website or something like that, the key piece of the document is basically the last section. It's called the claims. And the claims is sort of what the case law used to call it was the fence around your invention. So the claims describe what we actually say the invention is, and then the rest of the document is there just to support what we're saying. So interesting. Well, I think it's interesting. Most of you would probably find it a good way to either put something in your bird cage or put yourself to sleep at night. But it's having a look at if you go look at a patent document, or even if you're doing some competitive search sometime and you want to see what somebody else is doing and you come across some patents, that's the key piece of the document is the claim section at the back. That's where it describes sort of what the invention is. In addition to the claims and the patent sort of protecting you, as I mentioned here, it's also you also want to be sure that somebody else's claims aren't that fence isn't built in a way around what you want to do. So that's the whole sort of test of patent infringement, or you might also hear freedom to operate. Something that you might hear purely from a business perspective in the IP space as you're going along, doing a partnership, doing a license, taking on an investor, those kinds of things. You hear the freedom to operate terminology bandied around once in a while. And what that really is doing, and you might have to go to your lawyer and get an opinion saying, tell me about freedom to operate, either with respect to a particular patent that you know about, or do a search and see if what's out there. What that is basically saying is we've looked at the landscape, we've identified a couple things, and we're pretty happy that we're either happy that we're happy that we're outside the lines. The less good news you get from the lawyers if it comes back and says you're probably infringing, and then you might have to do some more work. But that's sort of what freedom to operate is all about. That's what that does. So patents, your filing date is what fixes your place in line. So you go to your filing date. Unfortunately, your patent's not going to come out the other end of the patent office probably for a few years. But the filing date is what protects you. It's examined in the patent office and they'll kind of have a look and see what they think is out there that might be similar or that isn't similar. And you'll have an opportunity to argue back and forth with them about that. In the Canadian context, the patent is 20 years. And the rule on this is fairly standard around the world. But it's a 20-year term from you might see the words the claim date. It's the first filing date, because when you go and start filing your application into additional countries, they all kind of often tie back to your first date. And the first date is what typically sets the term. In the Canadian context, we have to pay maintenance fees in the Canadian office. So one of the things I think you can do if you're in the startup space and firstly, you want your potential investor to think you know what you're talking about and you've done a little bit of homework, and really you want to have a good plan for this. Really, one of the best things I think you can do is sort of map out a little bit of a time chronology, and based on whatever you think maybe your geographic footprint is for your business, et cetera, and have a plan for what the cost structure looks like there, because you can unfortunately bat an eyelash and spend a ton of money on this stuff. And you just want to be prepared for when it's going to happen or structure that out. So in the Canadian context, one of the things you need to budget is, and in most countries around the world, you pay maintenance fees on your patent application. In the Canadian context, it starts on the second anniversary, once a year on the second anniversary of your filing date. Some other countries, the timing is a little different. I am not going to, how much time have I got left? I'm worried already. 13. Okay, I'm going to speed up a little bit. I am not going to go through this timeline for you, but I'm pretty sure these guys either I can get you a PDF of the slides or something, and or you're welcome to call me anytime, but I'm going to keep going so we kind of get through what we can here. Trademarks is the second piece and basically, ultimately, what we'll get to as we skim through this stuff is you probably end up in your business, depending what you're doing in your business, a little bit of a hybrid strategy about how you're going to protect your IP. So some cases, you might have patents and trademarks and copyright. In other cases, if it's not patentable, but it's different enough that you're not infringing somebody, you might just have trademarks, copyright, and maybe trade secrets or something. So building that kind of hybrid IP strategy is, I think, another way that you can maximize the value in your IP assets in your business. I'm going to just, with a trademark is typically, a name, a logo, a brand of your product. In some other country, it can be a color, it can be a sound, it can be one of the ones that was always in the US. This happens a little more. They tried to register a bunch of them in Canada. I'm not sure what happened with them, but also a three-dimensional trademark. So like the sort of the look and feel of even like a building or a space. Krispy Kreme Donuts was doing this for a long time. They were building a huge portfolio of trademarks around what their stores and buildings looked like. So you couldn't go build another restaurant well, you wouldn't want to go build another restaurant that had the lit up donut in the window, I guess, regardless. But so those are all sort of categories of trademarks that can exist. Using your trademark in the marketplace gives you some rights. You don't have to register it. If you register it, it puts you in a better position to enforce it and probably have some exclusivity around it. But if by getting started, you get started in the process just by using your mark first, and then sort of going from there. Canadian registrations in the trademark space are good for 10 years at a time, and the 20-year term of a patent is not renewable. It's not extendable. Once your 20 years is up, it's done. Versus trademarks, they can go forever. The 10 years at a time, as long as you're still using it and you want to still pay the renewal costs, you can just keep on renewing your protection of your brand. One of the things you potentially want to do similar to patents where you would do patentability searches and those kinds of things to just be sure that you have a feel for what the competitive landscape looks like or how novel or how you might approach drafting a patent. Lots of times as you're picking brands or product names or those kinds of things also, you potentially want to do a search. You can do a little search on your own online, or we can do a more elaborate search for you. You can get a lawyer to do a trademark agent to do a more elaborate trademark search for you. But one way or the other, it's not a bad idea to have a good idea of what is in the marketplace so that you can, again, tell that you're far enough away from somebody else's brand that you're not going to either even beyond an allegation of infringement. You just don't want to end up in a position that you're using a brand that's similar enough that you're wasting your time investing resources in building goodwill in a brand that is very close to something that somebody else is doing in the same space. So doing a search is a good thing to do with trademarks. These are all kind of things that you probably want to have in your background. Again, there's a little bit of a timeline or a little flow here, but I'm not going to dig into it because if Avery had let me talk for an hour instead of half an hour, I could have gotten into that, but it'll be okay. I'll just keep jumping here. So designs, I talked about these briefly. Designs are like, the shape of that water bottle could be an industrial design. It's not really anything to do with how it works. It's just what it looks like. So, a chair or a shape of a water bottle, or lots of times what people will use is design registrations crossing over with trademarks, or design registrations crossing over with patents to provide, like if you crossed over, if you invented a new product, you might patent a new product, but you might also try to protect the look and feel of the product with a design registration, so that you effectively end up with sort of a two-sided hybrid approach there. The next one is copyright. Lots of things with copyright. You'll pretty much everything you as again, the example I used to use is pretty much as your pen comes off the page, there's copyright in whatever you wrote. Lots of times now I'd say when your fingers come off the keyboard, because that's just it's not 1985 anymore like it used to be. But written work, computer code, all those kinds of things. Artistic works, music, paintings, three-dimensional, like as an architect, blueprints potentially, or even not even just blueprints, but also the actual appearance of the finished building can also be a copyrightable asset. So those are other assets that exist. Probably primarily, if you're working in the software space, it's mostly the code and or even the user interface. You can sometimes cook up a little bit of a copyright protection strategy around the user interface of your software, in addition to sort of how it behaves and how it works and those kinds of things. And again, with copyright, it's the perfect example of the idea itself isn't what's protected, but it's the way you've expressed it. So if somebody else expresses it in a substantially different way, even if it potentially does the same thing, ultimately, there may or may not be a strong sort of copyright protection element to that. Trade secrets, as I said before, confidential information could be anything from customer lists, formulas, instructions in your business, things that you've elected to otherwise not protect in a more public way. And where this sometimes becomes an interest area is people sometimes choose to use trade secrets instead of patents, because if they feel like it's something they can keep to themselves, or if you're out visiting, you're in the product manufacturing space, you'll have gone through any number of times. You have to sign an NDA at the door before you go into the lab. And part of the reason for that might even just be that there are some trade secrets to what is being done in there, and you've agreed that it's a secret and you won't rip it off. But those are the kinds of scenarios in which trade secrets might be useful assets to you. Okay, I don't have a lot of time left here. I'm happy, like I say, I'm happy to talk as long as you want with answers and questions and things after, but some of the general sort of things you would, beyond those types of IP assets and just basic lead into what they are and how they work. Oftentimes I would say to clients, there's sort of a defensive to an offensive IP protection spectrum. You might just be at a defensive end of the spectrum. You may just want to sort of protect yourself, protect your freedom to operate, not really care too much about somebody else trying to copy what you're doing a little bit, as long as they leave you alone and stay out of your way, through to the more offensive end of the spectrum, where you want to build that fence around what you're doing, and it's all yours and only yours, and proceed in that way. There's a little bit of a slide here talking about sort of layering together the different types of IP protection. This is sort of the whole hybrid strategy thing that I was talking about before. I'm sorry I'm not diving very deep here. I just want to kind of give you some ideas of what the topics are that you ultimately, what I thought it would be of value to a lot of people is knowing what a lot of the questions are that you might even be asked as you're trying to raise money, make a sale, build your business plan, those kinds of things. And these are, we're pretty much now getting to the point where these are the kinds of questions that you want to sort of be ready to answer, either have answered or be ready to answer. And again, I think there's great value in this if you're preparing a business plan, you're preparing a pitch deck to raise some money for your business, those kinds of things. Not everybody does this, prepares all this material. I think that even just preparing this material puts one of your feet a little further ahead, just the fact that you've taken and done the work. Hopefully that's not going to jump ahead on me. It's expensive. So building IP protection for your business on a startup budget is, again, this is an area in which you want to kind of, at least you want to plan out how and when you're going to have to incur your budget or spend your money. A lot of it's not avoidable expense. Well, some of it is. And in some companies, you might even pick your place on that offensive to defensive spectrum, depending on, frankly, how much money you want to spend on lawyers, which that's okay. You don't hurt my feelings. So if you're more at the offensive end of the spectrum where you're building protection strategy that either just in Canada or in other countries around the world as well, typically you're going to end up sort of a little bit in the deeper end of the pool in terms of cost. And what you want to usually where you want to start is sort of the whole idea, this prioritize the core. You want to have a look at the core of your invention, and probably you want to start there. Sometimes there might be little ways that you can build some added little bits to your fence with some added filings or whatever, but prioritizing the core is a big thing. One thing for you to keep in mind is that if you are on a plan that involves you filing patents, there's significant downside to disclosing the invention to the public before you file. So if you feel like, and that would easily include if any of you are, we're close enough down the road from the campus here at the U. If any, this includes publication. Like if you're going to publish your work, and in a way that people could tell what the invention is, these rules will apply to that project also. But generally speaking, if you find yourself in the Cadillac position of being able to make a plan against a white slate of there's no disclosures have been made already, those kinds of things, that's the scenario in which you can kind of probably be as flexible as you want to be in terms of particularly with patent filings, not so much with and to a lesser degree with designs. Trademarks and copyright doesn't really matter too much, but with patents in particular, if you are planning a strategy that involves you building one or more patents to put that little wall around what you're doing, you want to be careful that basically the basic rule is in many countries around the world, an enabling public disclosure, so an enabling non-confidential disclosure of your invention before you file a patent application somewhere, is you're dead in the water in terms of a valid patent. There's a couple things you can either sometimes patent around what your disclosure was if depending on what the subject matter is. In Canada, the US, there's a list of about 30 odd countries where there's a 1 year grace period. So you can still file a valid application up to a year after a disclosure. And truthfully, sometimes some people even they purposely decide to disclose and test the water with the product before they want to spend the money on the process. And that's okay too. But the public disclosure bar is something you really want to keep in mind because you're kind of dead in the water in terms of the big one is Europe. There's no grace period in Europe. So now depending if you're in the software space, lots of times people don't want to bother with software patents in Europe anyways because it's expensive and questionably broad, but it's a possibility. But so you want to keep the sorry. You want to keep the public disclosure window in the back of your mind. Look at that. Yeah, I'll just, so what have we got here? Let me just let this thing jump ahead here. Oh, actually, can you go back one? Yeah, okay. There's two more slides here that will give you, I'll be quick, but it'll give you just some little ideas. So one thing you want to be ready to answer about questions about is chain of title. So you want to be able to show that you or your company actually own what you're trying to protect. So if you own a company and you've got 17 employees and 15 of them have worked on programming, or if it's a manufacturing space, they've been working on the prototype manufacturing, those kinds of things. You ideally want to be in a position where either in their general employment agreement, you have ownership of any IP that's created using your tools within the time of your, on work time, et cetera. And you want to be able to prove that not only when you send the lawyer off to file a patent for you, sooner or later they're going to say, okay, we got to prove this and file some paperwork. Or when you get to the point of, oh, this guy isn't going to invest $5 million in my company until I can prove to him that there are no potential future headaches in terms of ownership. So chain of title is one thing that you want to, and again, country by country, there are some statutory defaults in terms of ownership. Like there sometimes are some in Canada, in the copyright space, there's an employment default. In the US, you'd hear it called works for hire. But there are some things in favor of the, so for example, in favor of the company. Flip side of that is if you're a contractor who is planning on retaining some ownership, you want to be careful about that too. Just to jump ahead there one more. International protection, a patent or trademark or something, if you register it, really only protects you in the country that it's registered in or the region that it's registered in. And if you want to, lots of, honestly, a lot of my clients here on the prairies, they're primarily interested in Canadian US protection. So effectively what we end up having to do ultimately at some point is file in Canada and in the US. We don't have to do the whole thing twice, but we have to go file it twice. Other countries also kind of are impacted the same way. And again, one of the good things with that is if you understand roughly what your geographic interest is, you can also, again, map out your costs and your budget, just so you got a nice pro forma that shows it's not a headache for you down the line. You want to jump ahead there? I'm ready to stop, and I'll stop there. Hopefully the last 5 or 10 minutes is probably when I was sitting there, I was thinking, what are the kinds of questions that I'm always helping clients answer when they are like, they're business questions. Truthfully, it's my favorite part of my work, but it's like, how do we put your business plan in the best possible position from an IP perspective to move forward? I'm going to stop there. I'm sorry if I scrambled around a fair bit. I promise if you come and see me and we have all our time to myself, you have all my time to yourself, you'll get some closer answers to what you need. But I'm happy to answer some questions or to stick around for a little bit after and chat some more. But thanks for all your time.
So big thanks to Corey for an exceptional presentation. I know we just scratched the surface. If you do get the chance to talk to Corey, I really encourage it. He's, taught me so much over the years, and every time you get a chance to talk to him, as you can see from today, you learn so much. So yeah, he graciously shared his contact information on the slides. So feel free to reach out, but let's not waste any time and open the floor for questions. We have one mic, so we'll run the mic in the room. So, oh boy. Please. Oh,
You broke it.
I broke it. Oh no. Here we go. So please just raise your hand if you have a question, and I will come to you. And if we have questions on the computer, I will pass it over to Adam or Abinit. I keep breaking the mic.
We actually do have a question.
Okay, perfect. Well, and we have one in the room first. Here we go. Please.
My name is Akash. Robot and AI, how cost optimization and making
Just keep pressing the button.
yeah, it's a registered in Saskatchewan, and right now we are an official partner with AWS, and also hello, yeah, also a startup member of Anthropic, large startup member, so a member of to and we are also a startup incubator member of Collab and cultivators as well. And right now we are having a partnership with a large organization to improve our AI tool. That is a part of our AI. So my question is, after we work together with this organization to improve our product, how will be the intellectual property of our product looks like? Come to, when it's come to trademark or copyright or even patent, how that IP looks like. So that would be right now the chair is the founder. So I want to know how it looks like after improving the product with that organization. And this organization is also part of Canada.
Yeah. Okay. Can I just, let me see how this works here. Can you guys hear me if I talk here? I'm happy to just talk. I'm gonna just talk without the mic. I'll just talk. So my understanding generally is that the question is you're doing something AI oriented in your business and you're partnered with another company who's giving you a hand with developing, enhancing, improving, whatever. The way that I understood the question is once they're done helping me improve the product, well, let me just tell you, I don't even have to finish telling you what the question is because I can tell you they might own part of it. If you don't have a contract in place with them. Now, you might have a contract in place with them already that says, here's, frankly, lots of times if they're in that type of business, a lot of those companies would actually have a contract that probably is signed with them. Either they will have with perfect disclosure or by having snuck it in past you, got you to sign something that either clarifies that you own it, clarifies that they may partly own it. It's probably mostly a copyright issue, I would think. And the copyright beyond whatever other kind of AI ownership issues might exist, the copyright between the two of you, in the US context, you'd be looking at the work for hire rules. And in Canada, basically, there is an argument to be made under the Copyright Act that if you paid them under contract to do that work for you, there is potentially an argument to be made that you own it. But if you're in the ideal position that you can kind of scratch your head a little bit and try to clean that up a little bit before you jump in too far, that's not a bad thing because honestly, I'm not trying to cause you a headache, but there may be a headache. And when the headache usually comes is when money hits the table. So not before then, but I don't know if that's helpful. Yeah.
I know we have a question. We'll see how long the mics work. Apologies, folks. Showing me that?
Yeah, it says that we are seeing a proliferation of AI adoption in varying degrees by individuals, research teams, and industry. How does IP law define ownership for assets created based on AI generated information? That's what this is on.
I'll try.
I'll try the mic and I'll try to answer the question. So I think this is an area that I've not read a whole pile of hard defined law in this area just yet. It's changing a lot. I think that if you were to apply existing rules to this, you could arguably say, no, and don't even get me started on the deep hole I went down this weekend reading all about this stuff about Anthropic's watermarking. That's a different story, but because it seems to me that on some level that could be used for them to try to claim authorship in something at some point, but maybe not. But if you were to apply the existing rules, AI tools are being used to develop you or your three partners are developing something together and you're using some AI tools to do it. I mean, the baseline would be, well, you use tools, but the people who actually were using the tools are potentially the authors. I'm not aware that the law is much different than that just yet, although I think it's an interesting question because let's face it, it's a question on everybody's mind. But I think if you were to apply, as a starting point to apply the existing rules would be, AI tools being used by someone to author something, the author could claim authorship. But there probably comes a point where you want to dive into that a little deeper. But I don't know if we're at a point yet where there's much different guidance yet in the law. I mean, there's a lot of the interesting case law so far on the AI stuff has been ownership, data ownership. So it's not even so much authorship and IP creation, it's data ownership. And even data ownership that people were the bodies of data that were being used to train AI models and that kind of stuff. So I don't know, Lucy, I think if I remember right, you said the name was Lucy. I'm not sure if that fully answers the question, but send me an email and we'll talk about it some more if it's still of interest.
Other questions in the room or online? Oh,
It's probably an easy one, but at what point in a physical invention, something that's physical ones, at what point can we file a patent? Does a patent physically exist, or do you have to design, or where in that path would you be?
I'm sorry, Avery's having to run around with the microphone. That's a good question. You're right. It's a pretty easy answer. When is an invention created from the perspective of, jumping into the pool with the patent process or something? Basically, as soon as you could describe what the invention is. You don't have to have built it. You don't have to have prototyped it. Frankly, lots of times if you can say, here's a cocktail napkin I drew at the bar of how I think it might work, and the three of my friends I was drinking with who were all going to claim inventorship later. Basically, as soon as you can describe what the idea is in enough of a way that it could be crystallized on a piece of paper or on the computer, then I think that's the position, and that's the point in time at which you have. I don't know if it's a finished invention, but that's the point in time where you could start thinking about the IP plan. Any other questions? Scott?
On provisional patents, how is the protection from the filing period of the actual?
Oh, provisionals. Oh, gotcha. I can. So, and what you'll, we'll see if I can get this to keep working. Can you guys hear that okay? Otherwise, Scott's in the front, and I'm gonna put this on here, and when it dies, I'll just keep talking. So what you will probably find as you are researching and jumping into the patent pool, there's these things called provisional patents, which is a US concept. We can do something similar in Canada. We just call it an incomplete patent, but it's basically you can file a quick and dirty application that just loosely enables your invention and gets you to the point that you have a filing date. So that because I don't have that timeline up here anymore, but the patent timeline really is driven by public disclosure, and it's that there's a 1 year deadline. So what you can do with a provisional application is you can file a provisional at that point you have a patent pending date, and you're not so worried about public disclosure. Frankly, lots of times what people want to do is they just file a provisional and then they can go disclose the thing publicly, or frankly try to make some money and sell it or test it or whatever. So what happens with provisionals, you file them, a US provisional is actually never disclosed to the public, so it never becomes public. What happens with the provisional is within a year, you have to file a regular one. And so if you file a regular, or frankly, you could refile it to set your dates back, or there's lots of stuff you could do. But what you do with it from a provisional to a completed application, and the provisional also gives you the ability to claim priority in Canada or in other countries, those kinds of things. So lots of times people use that provisional route or a Canadian incomplete application. If you're in a big hurry from a US marketing perspective or otherwise, then lots of times in the US market, the provisional route, frankly, your partners might care more about a provisional than they do about a Canadian one. The good thing with the Canadian one is and the good thing with the Canadian incomplete application, which works the same way, except it's ultimately laid open to the public, is the Canadian application, we don't have to pay in US dollars. So if we're working with startups, pretty much everywhere outside Canada, we pay for everything in US money. And it has become punishingly expensive to do this work anywhere. But I don't know if that totally answered your question, Scott, but yeah. No, it's a good way to start. Lots of people use that provisional route as a way to start because, it might cost you a few $1,000s or something like that to file a provisional, versus it might cost you $10,000 to jump in all the way and get going into the process deeper. Sometimes also with provisionals, you might go file 2 or 3 of them on different things and not really have a total plan yet of just how you're going to boil those together into final documents at the 1 year point. But it gives you lots of flexibility. So, yeah. Any other questions? I'd ask the microphone, but it's not listening to me anymore, which I think is the IT guy's way of making me shut up. But I'm happy to I'll stick around for a few minutes yet anyway. If people have more questions, I'm going to go see what's left on the lunch table and eat a sandwich for 5 minutes. But thanks to everybody for taking the time today to come and chat. Again, I'm sorry my remarks were kind of scrambly and around, but it's funny when I was talking to Avery's coworker yesterday, and I said, "Hey, remind me how much time I have to talk just so that I got it all cased." She's like, "You got about 30 minutes." I'm like, "Well, that's good. I created a 60-minute presentation." So again, hopefully there was some value, even if it was kind of all over the map, but happy to chat some more. Oh, my goodness. I don't know if it'll work for you or not.
Not sure this will stay working, but thank you all for coming out, and big thanks to Corey again for sharing his expertise and for being, again, very gracious and offering to, have anyone come chat with him. So thank you for attending. I would say if you haven't already, please feel free to subscribe to our newsletter. It's on our innovationsask.ca website. That way you're not going to miss an Innovation Saskatchewan event and you can come out to the next Discover series. We will get these mics figured out in the future. So again, apologies for the disruptions there. And then just want to say thank you. I hope you folks enjoy the rest of your day. Take care.